Anything to do with a certain religion, do you think?
No,
Is it anything like that?
No, it's more to do
no.
with a kind of a drug, isn't it? It's a drug.
Yeah, well, those that take it ought to be ashamed of themselves.
According to The Sun, there were thousands of empty ecstasy wrappers littering the floor of the 250-foot-long hangar.
Drugs, sex, sensation.
Some newspapers have called acid house music a sinister and evil cult which lures young people into drug-taking. The message is certainly getting across.
The organisers kept the location secret until the very last moment, which was the main reason, according to the papers, why there were so few police here and they were unable to act.
Drug-crazed kids, some as young as 12, boogied for 8 hours yesterday at Britain's biggest ever ecstasy bash.
The party took place here, infiltrated by reporters from the Mail and the Sun.
There's meant to be a drugs-related craze.
What do you know about acid house music?
It must affect the brain in some way.
Unless it's just the music that does it.
All them lights flashing don't do you any good either, do it? I wouldn't even go in the pub where them lights are.
Oh, no.
They drive you mad, don't they?
Welcome to the 88 podcast with yours truly, Wayne Anthony. And on today's podcast, we are going to be deep diving the declassified acid house files that were released by the government in 2016 after remaining confidential for nearly 30 years. We're going to be deep diving those files. I haven't seen anyone covering them anywhere else other than the mainstream media, which we'll have a quick look at now. So firstly, a little bit about the files themselves. Where are they? Here they are. These are the government files themselves. It's a PDF that you can actually download from the National Archives. You can see they've only released 47 files. And you can see them here. I'm just scrolling through a few of the files. These files were from the Home Office, and they include letters from Margaret Thatcher, Geoffrey Howe, Virginia Bottomley, and a few of the other MPs that we all know about from that period. There's Geoffrey Howe. So there's 47 files. So we're going to be going through some of these files, and what you'll find is that you'll be quite surprised on what actually galvanized Margaret Thatcher and her government to actually do something about acid house parties. Now, remembering that in my podcast, Media Hype Part 1 and Media Hype Part 2, we covered a lot of the acid house articles at the time. And if you remember, there were really a lot of sensationalized headlines, and they were quite dramatic. And a lot of them had drugs in the headlines, or, you know, some of them even had terror in the headlines. But most of them had drugs in the headlines, you know, 20,000 youngsters out of their heads on acid, or, you know, 25,000 kids on acid, and 20,000 kids on acid, and 3,000 kids on acid, and 4,000 drugged up kids. So there were lots of headlines that featured the word drugs, and these headlines were being published from 1988. So from 1988, there'd been a lot of high profile articles relating to acid house and connecting it to drugs such as MDMA and acid. I mean, they were both true, to be fair. And so what one would think that after all these headlines, that Margaret Thatcher and her government would actually be really active in stopping these events because of the danger it presented to, as the newspapers continually to publish, teenagers. So essentially, the newspapers are calling us all teenagers, even though we weren't teenagers. And all of these stories, I mean, literally, there must have been easy 60 articles at this point. But Margaret Thatcher and the government, they weren't actually seen to do anything until August of 1989. But what you'll find in these declassified acid house documents was that they were galvanized to actually do something about it after, you know, one of their friends was kept up all night from a party that was in a field next door. And so the main issue with the government wasn't drugs, it was in fact noise and noise pollution. And for years before Acid House, they've been trying to find ways of making noise an actual criminal offence. And this could be, you know, noise in the streets. It could be noises from factories, you know, a nightclub, whatever it could be. Noise in general, they wanted to make a criminal offence. But we'll have a look at some of the press here. I mean, we've got the Lancaster Post up on our screen at the moment. And the headline for the Lancaster Post, which was covering the release of these files, is this: Thatcher push for plug to be pulled on noisy acid house parties. Margaret Thatcher urged the government to combat the new fashion of acid house parties as noisy all-night raves plagued 1980s Britain, according to newly released official files. And I'm just going to read a little bit of this. The Prime Minister called for immediate action to prevent the spread of parties celebrating the new genre of electrical dance music in 1989, as residents complained of being kept up late at night by revellers. But one of the things you're seeing some of this coverage from the press. So that was the Lancashire Post. Now this one, what's this one? I can't really tell who's this one. Digital Scholar, G. Cornish. Again, this again is covering the release of these documents, and this is quite a nice article. Blah blah blah. It's quite long to go over right now, but so you can see there's people talking about it. Here's another one from the Daily Express. Margaret Thatcher wanted acid house parties banned because they were not licensed. And if you look a little bit further down into the page, it says, there's a little quote from one of the documents that was written by an MP called Carolyn Sinclair. And it says, drugs are not the main issue. The parties are a form of unlicensed public entertainment, which would shock quite a lot of people, given that everybody thought that drugs were the main issue. I mean, here's another story. This one is in The Sun. And this one says, rant and rave. Margaret Thatcher launched urgent attack on invasion of 1980s acid house parties after police recorded 223 in one summer. And this is the summer of 1989. The ex-Prime Minister was more concerned by the ravers' noise than drug habits and pressed for urgent action when one village was kept up until 7:30 a.m. So there wasn't. It appears that they wasn't really that concerned with the drugs. And here's another one from factmag.com. Drugs weren't the real reason Margaret Thatcher tried to ban acid house. Cabinet papers reveal how the Tory government targeted 1989's new fashion, inverted commas. The growing use of ecstasy wasn't the real reason Margaret Thatcher launched a crackdown on acid house raves in the late 80s. Recently released government documents have revealed. So, again, Carolyn Sinclair has been quoted. Drugs are not the main issue, wrote government official Carolyn Sinclair in the memo, with a handwritten note adding, there's also surprisingly little alcohol. Because these were crimes that you could actually be charged for and criminally charged for and criminally prosecuted. And so at these parties, we were all drinking non-alcoholic beverages, which mean we didn't need a license to sell drinks. And so that was a bit of an issue. They couldn't get us on that. And we literally didn't have any alcohol in the building. There may be a few bottles of champagne, here and there, but not many. It wasn't like, in the 90s, it became a thing where people were, I mean, I'm guilty of it too, where people are standing around in groups, everyone's got bottles of champagne and all that type of palaver. But during the acid house days, you didn't really see that. We did it a couple of times. I mean, Jarvis was really the big instigator of champagne. Jarvis loved a bottle of champagne. And, there were times where he would just bring a few crates of champagne and just go, here we go, lads, cheers. But, I mean, Jarvis, he kind of come from that hip hop world as well. So you kind of half expect it. But generally speaking, we hardly drank champagne at acid house parties. And we didn't drink any alcohol at all at acid house parties. So they couldn't get us on that one. And so that's that one. Is there one more? I think there's one more. Sky. This was Sky News. And the headline is, Real Reason Thatcher Tried to Ban Acid House Parties Revealed. Officials feared the rise in dance music culture, but were more worried about noise nuisance than the use of illegal drugs. I mean, this is really surprising to a lot of people, given all of the headlines that came before this. It goes on. Margaret Thatcher tried to stop the new fashion, and they're putting new fashion in inverted commas because that's a direct quote from Margaret Thatcher. We'll see on one of the documents during this session or another session. And so I noticed in a few of these newspapers, they've actually quoted that. So new fashion in inverted commas of acid house parties after an all-night rave shattered the tranquility of a Tory MP's uncle, newly released official papers show. So you could see that a few media outlets did cover the release of the documents. And so what we'll do is, before we go on any further, let me first give our network a little plug. I rarely do this, but because we're so new, we've just wet our heads, really, so we need your support. And as much as I hate saying it, come over to our YouTube channel. We need some subscribers. We need some comments. And we've got some good stuff on our YouTube channel. We've got stuff that we actually make just for the YouTube channel. And we've got all our episodes, as you can see. So far, we're up to number 10. Well, this is actually number 11. And as you can see, there was episode 9 is Media Hype Part 1, which we covered lots of these newspaper clippings that I was just talking about, the ones that contained all the dramatic headlines. And I also covered that again in Media Part 2, Media Hype Part 2. So we've got a good channel. We've got clips. We've got the actual full podcast. We've got acid house documentaries, house music documentaries, dance music documentaries, and lots of other really good stuff. So come over, subscribe, hit the notification button so you actually get the videos when they actually get released. That's quite handy. We've got an Instagram page. Come on to Instagram. Give us follow us in there. Also give us some comments, tell us how we're doing. So give us some support on Instagram. And we've also got a Facebook page. We're posting stuff on all the networks we can, and we're trying to create independent content for each of the networks. And also check out our official webpage, which is the88podcast.com. You can find everything you need in relation to the podcast here, with all the links to the different podcast networks, the YouTube videos, and the actual podcasts themselves. All the podcasts are listed. You can see, just to give you a quick recap, that, I've spoken to Tory Cooper, Ian Mill, the boys from Energy, the Rave at the K Firm, Richard from Rain Dance and Pez. We spoke to Joe from Labyrinth. We spoke to Gordon Mason about They Call It Acid feature documentary that everyone wants to watch. We spoke to the keyboard wizard himself, Adamski. and we did 2 episodes dedicated to the media hype. So get over there, and on the website we've got lots of the show notes which will actually give you a little rough idea of what to expect from the show. So have a little look, come over and give us some support. So with that done, let's crack on. Now, a lot of articles have spoken, they have actually quoted this letter. Now, this letter we're about to read, although this date, as we're looking at it, it says September the 6th, the letter was actually written 22nd of August 1989. And this is the actual first document. This is the earliest document in all of those released documents. And it's the earliest dated document. So it seems like there was a whole flurry of communications that actually occurred after they received Margaret Thatcher, after she read this letter. And this is the actual letter. This is actually a cover sheet for the letter, but this is the actual letter where they took that quote from New Fashion. And those that are looking, and actually now I'm looking at it, it's this here. People that are looking, you can see that Margaret Thatcher has written a handwritten note on top of this covering letter, and she has also put fashion in inverted commas. So yeah, so that's where they got this from. So I'm going to read this article so we can actually go over it, so those that are listening know exactly where we are. So we're looking at one of the released documents. It's on a House of Commons letterheaded paper. It's from, and well, it's a bit confusing who it's from and all that, because it's got, at the top of the paper, it's got Archie Hamilton, MP. But I think this is from Andrew Turnbull, Esquire, the Principal Private Secretary, 10 Downing Street, London, SW1. Dear Andrew, please find enclosed a copy of correspondence from my uncle, Mr. Gerard Coke, inverted commas. No, I put those commas there. Of Jenkin Place, Bentley, Hampshire, who is very disturbed by an acid house party that took place in his village recently. He wanted me to bring it to the notice of the Prime Minister, and I would very much like to be able to tell him that I have done that. Yours, and I think this must be Archie. So this is a letter from Archie Hamilton, MP, to Andrew Turnbull, Esquire, who is the private secretary to the Prime Minister, Margaret Thatcher. And obviously it's all very powerly, you know, it's my uncle, he wanted me to make sure that you got it type thing. So it's quite pally, and I would love to be able to just write off a letter just like that. So let's look what he's actually saying. So this is the letter written from Mr. Gerard Coke, CBE, DL. And it's written to a Lieutenant Colonel Michael Mates, MP, 22nd of August, 1989. Now, those are people that can actually see the document, but I'm going to have to make it bigger so I can actually read it. Dear Colonel Mates, I am afraid that you will be bombarded with letters about the acid house party which took place in Bentley on the night of Saturday, 19th of August. I'm sorry to add to the deluge, but as I was concerned for many years with the lay administration of justice in the country, and as one of the oldest, both in age and length of residence, inhabitants of the village, I feel I should lend what weight I can to their representations. As you probably already know, the noise, which started at 1:30 a.m. and went on until 7:30 a.m., kept the whole village, including the Quinton nursing home with some terminally ill patients, awake, and was heard for more than a mile in all directions. One man at Rowledge, in Mrs. Bottomley's constituency, about 3 miles away as the crow flies, could not sleep and drove over to see what was going on. Virtually everyone in the village rang the police at some stage, but the answer in every case, including to me when I rang anonymously, was that this was a private party and they could do nothing. At a time when the Alton police did not answer the telephone, one neighbour who rang Winchester because he could not get no answer from Alton discovered that the police were involved in another similar party, which I see from this morning's paper was at Fareham, which had developed into a riot which had obviously occupied police personnel and resources. That's page 1. Part 2. I'm going to have to increase the size. Give the police whatever powers they need to enable them to deal with these invasions of privacy, which is what they really are. Because prevention is better than cure. Surely the easiest way to deal with the trouble is to make an assembly of doors starting or continuing after midnight, subject to a magistrate's license if it is likely to exceed, say, 30 in number, or if sound reproduction and amplification equipment is to be used. At least 3 or 4 weeks' notice would have to be given, and the police would be entitled to be represented and to object if the chosen area could be difficult to control. If the license is refused, it is a much simpler task for the police to prevent cars reaching the site than to interfere with a party which has already been going on for an hour or two. Using licensing by magistrates, courts could control these gatherings, does not entail setting up new machinery and could be quickly implemented by a short bill, which would presumably include substantial penalties against both the organisers and the site owner, who will be receiving a large rent for arranging an assembly without a license. So they want to hit the landowners as well and the venue owners. But of course, it is not for me to suggest the best way of dealing with a problem which has been aggravated by the long hot summer. I think, however, that it must be said that these gatherings are partly provocative in character, and those who attend them are half hopping for a confrontation with the police or local inhabitants. Some unpleasant incidents have already occurred, and I am glad to say that our local example passed off with it's some French and I can't actually read it, with blah 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 blah. This is when my French lessons could have come in handy. And the last page, a riot or near riot resulted in casualties. The government would come under severe criticism for having made no attempt to deal with the root cause, and you have enough troubles on your hands without adding to them. Exclamation mark. I hope that you will not mind that I have sent a copy of this letter to my nephew, Archie Hamilton. Having been Miss Thatcher's PPS, he may be able to ensure that she is made personally aware of the need for action. Please, no answer needed. Yours sincerely, signed, Gerard Coke. There you go. So this letter is actually what kickstarted the government's reaction, because there was lots of, as I said, a flurry of communications happened after this occurred, after this letter was sent. Right, so here's another document, and this document is the Carolyn Sinclair document that we're speaking about in those other news articles. And the Carolyn Sinclair document, now remembering this is a confidential document that was released nearly 30 years after the fact. And this was in reaction to a flurry of letters that were all instigated by the Gerard Coke letter, complaining about noise in a field next door to his property, but also it kept a whole village up, you know, however many people are in that village. And you'll see from this document, it's a 5-page document. And I'm just showing the document to those that are listening. And this document was prepared for the Prime Minister. So the Prime Minister actually got to read this document. So it's stated at the top of it, it says Prime Minister. It's dated the 12th of October, 1989, and it's headed Acid House Parties. And I'm going to read basically what it says. I'm going to read through it. This note examines the options for dealing with acid house parties currently being considered by the Home Office and the Department of the Environment. It concludes that the most promising course is to tighten up existing public entertainment licensing rules with much tougher penalties and confiscation of profits. Background. The main problem with acid house parties is the nuisance caused by the noise. The police wish they were called pay parties. Drugs are not the main issue. The parties are a form of unlicensed public entertainment for which people buy tickets. And a handwritten note, because this was obviously one of the different versions they wrote up. And there's a little handwritten note that says, there's also little, I'll just go a bit closer. There is also surprisingly little alcohol. So that's something that one of the newspapers mentioned. And I just want to point out with this, what I've just read out, and that is, if you can see, the main problem with acid house parties is the nuisance caused by the noise, which is just, I mean, that's alarming to some people. Some people shudder to the core to hear that the main nuisance was the noise. And drugs are not the main issue. I mean, it actually says that drugs are not the main issue. They want the parties to be called pay parties, because remembering at this time they were called acid parties, whereas parties, dance parties, some people were calling them raves. You know, no one, this term pay parties, you know, no one had even heard of that. I'd never heard of the term pay party until the police pay party unit was devised, and this was all after now. So the police pay party unit, which was a special unit that was a nationwide unit, that for the first time, they broke a lot of firsts. And one of them was that they had a computerized network that was connected to the entire country, to all the police stations in the country. And they could all feed live information into this database, which will update around the country again. And they were using it to document everyone that was involved in the acid house scene. And it could be anybody that they pulled over, DJs, it could be the lighting guy, rigging guy, it could be the sound guy, but mostly it was ravers or party goers, because they were being stopped on the streets and their names were being taken, and then obviously they were asked if they knew who the organisers were, do they know any of their names, and basically they were encouraged to snitch, especially if they might have had a couple of pills on them or something, because generally speaking, this is October 1989, you know, people wasn't taking excessive amount of drugs at that time. People were taking 1 or 2 pills maximum, and they were having a great time. So most of these people that they would have been stopping would have had 1 or 2 pills on them. And so suddenly they would have been in a bit of a tight corner, because now they're going to be presented with charges and they're going to be arrested. And so they would be offered freedom if they could go and find out who the organisers were of these parties. Think that drugs wasn't the main issue. It's alarming. And the Prime Minister is reading this document, you know. And the other thing is this pay parties term. It's obviously the reason why they wanted them to be called pay parties was because it put them in a different bracket. And this bracket or category came with a whole set of different laws. And this term, I've never heard it before, as I keep saying, but I think that it's probably comes from an earlier youth culture movement. You know, it could have been the Teddy Boys, it could have been the blues parties, it could have been any one of these different cultural movements. And now they're reinventing it for acid house. And after then, I mean, it's curious because after this letter, they did start calling them pay parties. And even the newspapers started calling them pay parties. And I've got lots of newspaper cuttings that even in the main headline, they use the word pay parties. And so, and when, as I said, the police unit was called the pay party, the police pay party unit. So the police wish they were called pay parties. I mean, come on, dude. So there are 4 ways of combating the noise, because here again, they're focused on the noise. They don't care about the health issues. They don't care about the drugs. They just care about the noise pollution and ways of controlling that noise pollution, because they want to make noise a criminal offense. There are 4 ways of combating the noise. 1, under the licensing law which governs public entertainment. 2, under Section 14 of the Public Order Act 1986. 3, under the common law powers available to the police to prevent public disturbance. So they're going to use common law against commoners, against the people, essentially. And 4, under the Control of Pollution Act 1974. Now, I imagine that is something to do with noise, because I think noise comes under the Pollution Act and they call it noise pollution. So I imagine it comes under that Act 1974. And so going on, so 1, public entertainment licensing law. So now they're going to break down exactly in these 4 categories of how they're going to tackle it. So the first one being under the licensing laws which governs Public Entertainment Act. So 1, public entertainment licensing laws. All indoor entertainment, including acid house parties held in a building, needs to be licensed. Page 2. An organizer should apply to the local authority for a license 28 days in advance of the event. He is obliged to notify the police and the fire brigade at the same time. Conditions may be imposed when the license is granted. This is a way of controlling the numbers, noise, and duration of the parties. Now, these laws are already in place for pop concerts, festival type events. And so now they want to bring party promoters in line with that, in line with those licensing laws. Now, when they're talking about controlling the numbers, noise, and duration of the parties, it was years after this, probably a couple of decades after this, how this licensing process developed was in later times they found ways of controlling genres of music. And so there's a good example of like the grime music scene in London or in the UK. And they were, if any club promoter that could, because what was happening was, as part of the licensing application, you had to declare what genre of music was going to be played at your event. You also had to give all the DJs names, and they all had to be have no criminal records. Yeah. And they had to have the DJ's home address or a address. And later on, this is how they was able to control genres of music. And this is how they tried to control the grime music scene. When anybody put grime as a genre of music on their application form, they were refused. And this went on all venues across London, probably across the UK. And so this was one way that they could control a certain genre of music. And to be fair, that genre of music came with a certain class of people. So they were controlling two groups. One, they were saying that the gangs were connected to these grime acts. And so they were trying to control, they didn't want any trouble to be happening at any of their events by any gangs coming together. But because of that, they were able to control when and where these events could take place. And so, although these were just the early days of those laws, these laws eventually, when they say this is a way of controlling the numbers, noise, and duration of the parties, they went a lot further than that and they controlled them in all facets. I mean, the fact that it came to a stage where the DJs had to have clean records. DJs, I mean, they're not there to do any brain surgery, they're just there to play some music. But they had to have clean records. And then if a DJ, because I know this happened to lots of DJs, if a DJ was at an event where trouble happened, then that DJ would be tagged as being troublesome and playing at events where trouble is normally caused. So if I was a party promoter and I wanted to book this DJ, they would basically, it would be called in question the whole event because this DJ has been found to play at events and that where there's been trouble. And they bumped into the mic. They obviously have massive databases in order for them to know exactly who did what and where and how. And so this is 1989, and this is the early stages of that process. And so this is a way of controlling the numbers, noise, and duration of the parties. That's an understatement going on. On outdoor entertainment, the law leaves it to local authorities to decide whether a license must be obtained. This is mandatory in some areas, but not in others. The problem is that most organisers of acid house parties are flouting the law by not applying for a license. So even in that statement there, it shows you that although they're changing these laws and creating much tougher penalties, they know that the acid party promoters who are breaking into warehouses or, paying for a landlord's field or paying for a landlord's warehouse whenever possible, that they're not applying for licenses. So who is this targeting? This is targeting and current pop promoters, festival promoters, and anybody else that wants to do any type of event in the future. It's targeting them. And not acid house promoters, because acid house promoters such as myself, we would never be granted a license. Your Sunrise, your Energy, your Biology, your World Dance, Genesis, there's lots of others we can mention. No one would be getting a license. So that's for sure. Well, they made it clear we've tried to get licenses. Where a license is required, it is a criminal offence to hold a public entertainment without one. A local authority which gets wind of a planned party without a license can apply for an injunction to stop it taking place. Windsor has already done this, but the penalties are limited: £2,000 fine or imprisonment for up to 3 months. Now, this is the current laws. There's nothing new about this. They could do this currently, so they're not really doing much to change it there. What they're highlighting with this issue is the penalties and the sums involved: £2,000 fine or imprisonment for up to 3 months. So this is what's being highlighted here. They want increased penalties, much higher fines and imprisonment for promoters, but longer prison sentences. Going on, it would be possible to increase the penalties sharply. The fine could be unlimited An unlimited fine. Can you imagine? I haven't even heard of that before. Unlimited fine. And a link could be made which allow the proceeds of acid house parties to be confiscated in addition to the fine. So if you're a party promoter, you've been nicked for this and you've been prosecuted, they can take your house, they can take everything that you have in much the same way they would deal with, I imagine, a drug dealer. You know, they could take everything that you've earned up to that point. Let's say you've been doing it for 10 years, you know. So where are we? An increase in the penalties would require legislation. The Home Office are thinking of a private members bill. See, later on, I think this private members bill happened a little bit later. Probably maybe in 1993. I'm not sure. I could be mixing it up there. And because if you remember all what happened around that period as well, I mean, that's quite big. The Criminal Justice Act and the Private Members Bill, I'm sure it's that. The link with the confiscation provisions in the Criminal Justice Act could be made by order. So they want to make sure that whatever happens, they get what they go after, whatever that might be. So Section 2 is Section 14 of the Public Order Act 1986. This gives the police powers to impose conditions on the size and duration of a public assembly held out of doors, but they do not have similar powers to control an assembly indoors, example, an acid house party in a warehouse. So the current Public Order Act means that they can basically, you know, tell you, they can control the size and they control, well, this isn't even talking about parties. This is actually talking about public assembly full stop. So this gives the police the powers to impose conditions on the size and duration of a public assembly outdoors. So that public assembly could be anything. So they're trying to find ways of linking this to acid house parties and pointing out that this still has no bearing on whereas parties or parties that are kept indoors, staged indoors. Extending Section 14 powers to indoor gatherings would require legislation because they were pushing for this change of the law. Officials believe it might be contentious. Now, why are they thinking it might be contentious? It would have to be a general power, not one directed specifically at acid house parties. You see where they're going with this? Apparently, consultation before the passage of the Public Order Act 1986 did reveal misgivings about an indoor power for the police. So what they're saying, it's not just going to be for raves. It's not just going to be for acid house parties. This is going to be for everyone. Weddings, funerals, christenings, birthday parties, any type of gathering, any type of public assembly. This is targeted. And that's why there's misgivings about the indoor part of it, because with the indoor part, there are obviously clearly different laws which govern indoor events. And the last section, which is section 3, which is not the last section, is common law powers. Strictly speaking, the police have no power to intervene to stop a party purely on the grounds of noise. But if they receive complaints about the noise, they can intervene using common law powers. The greater the volume of complaints, the stronger the case for acting to preserve the peace, in commas, least citizens take the law into their own hands. So what they're saying is that if there's some type of noise complaint, that they can come and stop your event, and they can use excuses such as, you know, the locals are going to take the law into their own hands. and come and stop the event themselves if we don't stop. So it then becomes a security issue, it then becomes a public nuisance issue, and then they call in the riot police. So where are we? So yeah, the greater volume of complaints, the stronger the case for acting to preserve the peace. So they want people to complain, so they will probably step back, let the noise pollution go on for as long, as loud as possible, hope that as many people as call and complain, and then act on that, but essentially stand back and watch. The reported reluctance of the police to intervene is due, and this, I guess we're talking about indoors. No, we're talking about everywhere. The reported reluctance of the police to intervene is due, A, mainly to the sheer numbers involved in some of the parties. The risk will be too great, which is absolutely true. B, slight nervousness about relying on common law powers alone. This leaves them open to challenge. So anyone that knows the common law and knows their rights could back them off and say, no, you can't use those laws for this assembly of people. And they were going to use common laws to stop the events because they had no legislation at that point to change the laws, because the only thing they can really do is increase the penalties, fines, prison, confiscation orders, the whole 9 yards. It's exactly the same way they would deal with a drug dealer, for example. Too much weight should not be put on B, which is a slight nervousness about relying on common law powers alone. This leaves them open to challenge. The police have been using their common law powers effectively to stop acid house parties taking place. See attached article in the Express. Now they're talking about a news article. And one of the things that we found that was happening a lot during this time, and even in speeches that were being made in the House of Commons or at Parliament, that the MPs were using these sensationalized press coverage in newspapers, and they were holding them up in the House of Commons or at Parliament, and they were using them as examples of what was actually happening. So all of those sensationalized headlines, they were using it to scare the other MPs into action as such. And four, which I guess is the last section, which is to do with noise, Control of Pollution Act 1974. Excessive and sustained noise measured in decibels is a civil offence under this act. Enforcement is in the hands of local authority environmental health officers. The police are seldom brought in. Most cases involve noise made on construction sites or in factories. Remedies through the court is slow. So here again, they're talking about noise pollution, and they're not just coming after the parties. They're coming. They want to make noise an offence, and I know I keep barking on about it. And this is one of the reasons the police are seldom brought in, and the remedy through the court is slow. So it's got no effect on the acid house party that's happening there and then on a Saturday night. The Department of Environment have been thinking for some time of making noise a criminal offence. They would like support from the police. Environmental health officers can find themselves intimidated on building sites and in factories. So there you go. This is a document prepared for Margaret Thatcher, the Prime Minister of England, the United Kingdom, and they want to make noise a criminal offence. Virginia Bottomley, MP, this is MP Virginia Bottomley, has written to local authorities asking them what they think should be done about acid house parties. Making noise a criminal offence is canvassed as a possibility. But this does not look attractive. Look, see, they want to make noise a criminal offence, but they're scared. They're scared that the people will just not accept it. And by people, we're not talking about ravers. We're talking about the people of the UK. We the people. I don't know if we got we the people, but they're talking about us. And so they have to give it to us gently. They have to use a lubricant. But this does not look attractive as a means of dealing with acid house parties. It is too broad brush. It would involve the police in every row about a neighbour's party and enforcing noise control in factories. This may be something we want to do, but it would need to be justified on wider grounds. Conclusion. There are adequate powers to deal with the problem, though some local authorities need to be encouraged to make licenses mandatory for outside entertainment. There is already a requirement to notify the police in advance under the public entertainment licensing rules. In commas, the police themselves seem to be in a muddle about this. The problem at present is that those organising the parties mostly ignore this requirement. What is needed is a way of hitting at the profits made by the organisers. This should discourage the craze. Much tougher penalties for failure to obtain a licence should help. So would confiscation of profits, though the police would have to be able to prove that the profits came from the event in question. The licensing rules can be used to crack down on acid parties without new bureaucratic procedures which could catch every wedding party. Home Office officials are working up a penalties confiscation package designed to make the public entertainment licensing law a more effective tool for controlling acid house parties. It looks sensible. Meanwhile, the police should be quietly encouraged to use their intelligence to stop illegal parties taking place, working in conjunction with local licensing authority. No amount of statutory power will make it feasible for police forces to take on the crowds of thousands on a regular basis. We cannot have another drain on police resources equivalent to policing football matches. Signed off by Carolyn Sinclair. Let's just go back to something that I said earlier. Now, so again, there are adequate powers to deal with this problem. The licensing laws already said that promoters would have to contact the police in advance of their events, a month in advance. They would have to get approval from the police. They would also have to get a health and safety approval from the fire brigade, especially if it's not a already licensed, a pre-licensed venue. So if it hasn't already got a license, i.e. you got some warehouse and you want to get that license, then obviously they're going to bring in the fire brigade to check that the health and safety from that end. They're really highlighting the fact that factories and are the biggest culprit of noise pollution. And so if they can bring these laws in on the pretense of acid house, then they in effect could deal with the factories. But obviously these are MPs sitting in Parliament. You know, they haven't got boots on the ground. And so the practicality of holding, going to factories and taking factories to court, factory owners to court is slim and lengthy, like what they were saying. They need something more instant, something which they can implement immediately. So they mentioned in here about the decibels and measuring the noise pollution using the decibel machines. And this is something that they actually did. They actually implemented this quite quickly. And it seems as if local authorities would be responsible for carrying out this process. And part of your entertainment in uh, application was that you agreed that you would have these dudes would come with their decibel machines, and if they would, they would be within, I don't know, a couple of miles, maybe even 10 miles. It depends. I suppose if you're in the countryside, the music travels quite far, but they would be within a certain radius of the event, and they would take different measurements, and on their decibel machine, if it goes over what is decided is the adequate, you know, reading, then the promoter, because now obviously you've got a license, so they know who you are. The promoter would then get fined. And what they would actually do, most of the people that got affected with these decibel meters were actually locals. They were normal, everyday people who were having parties in their homes, be it wedding, christening, whatever it might be. They were the ones that were getting hit with these, and there were fines involved too. So what would happen? There would be noise complaints made about your party, and let's say it's a birthday party and you're having it in your house. There'll be complaints made about your birthday party, and I guess because that they saw that there was a pound note in fining people, they would have some department, and I guess that they were open till late because they would send out an inspector with a decibel machine, and it could be at 2 in the morning. And he would come and he would go outside your property and he would take measurements of the noise that was being generated by your gathering. And I think that they could actually decide there and then. They give you an official warning to say turn the music down. And I don't know if they give you 2 warnings or you get the one official warning, but after that, they can actually confiscate whatever it is, the source of the music. So if it's a sound system, they could confiscate the sound system. And there's nothing that you could do about it. I mean, yes, you might have to apply in, to get it back. You might have to appeal for it, but I don't think you were getting it back. I think when our warehouses got crashed and all of the equipment was seized, a lot of the time, if you could get it all back most of the time. And that was because if you could just be a rental company that got fooled just like anybody else into renting your equipment to this group of people. And so they wasn't really held as the responsible for the party itself. So if you presented the receipts, you could get that equipment back. But what they're talking about here is they actually confiscated your equipment, confiscated your sound system, and I don't know if you get it back. You certainly don't get it back on that night. So one of the immediate things they did from this, and this was by 1990, they had these guys, these inspectors running around with their decibel meters, and they had the power to call the police as well, because they wouldn't be knocking on your door and asking, to give up your sound equipment without police and a bunch of guys with them. So they would turn up at your house with a team of people. So that was one of the things that came out of this, that they wanted to make noise a criminal offence. They wanted to increase the fines that party promoters got for staging parties without a license. They wanted to confiscate any profits associated with that party. And I guess if they can prove that you've done other parties, that they would take that money as well. It made it harder for the current crop of pop concert promoters to organize pop concerts, and they created the early beginnings of a law which would just control large groups of people, and those groups of people could be established by the music that they listen to. I mean, that in itself, that was something they tried to do for years. Imagine that they could just control one particular group of people. You know, like they tried to control the grime scene. I mean, that's incredible amount of power to have. But this was the early days of that. So again, this was a confidential document that I downloaded from the National Archives. Let's take a look at another one. So here's another document. Now this is all about response. Now I think this was November. No, 9th of November 1989. Again, this is another official document that was confidential and only recently made public, well, 2016. But the Association of District Councils, it's headed. Response to a request for information concerning acid house parties. Now, it's quite a lengthy document. Let's have a look. It's 6 pages, but it's quite text heavy. But there's some really important stuff that I noticed. I only just skimmed it, so I haven't read it in advance. And I noticed some really interesting stuff that were in there. And so I want to read you some of it. I might read you all of it. We'll see how we go. So number 1, in introduction, 1.1. The association has consulted all of its 333 member authorities and ascertained that nearly 30 have had direct experience of the acid house and pay party phenomenon. Pay party, inverted commas. It is clear from these responses that district councils feel that the powers contained within the Control of Pollution Act 1974 and the relevant sections from the Local Government Miscellaneous Provisions Act 1982 and other legislation are inadequate to deal with these parties. 1.2. Pay parties have existed in various forms for some years and have mainly been confined to inner city areas. Such events have typically only required action by local authorities to deal with noise nuisance, with the main action undertaken by the police officers who deal with the associated illegal drinking, drugs, and other criminal activities. Over the last 2 years, the problem has been generally of manageable proportions, although it has never been felt that the legislation was adequate. The recent so-called acid house parties are on a much larger scale, with more people, more noise, and more public disturbance. 1.3. It is clear that, even disregarding media hype and public perceptions, many of the organisers have few scruples about obtaining venues by deception and are not concerned at the effect on local people. Thus, the events become, in reality, unlawful, unlicensed public entertainments, which result in gross noise disturbance extending over a radius of several miles. They lack suitable safety arrangement, create serious traffic congestion, and may result in problems involving public order. 2. Legislation. 2.1. In the main, local authorities have used 3 legislative means of control. Firstly, the control of the Pollution Act 1974, noise nuisance in brackets. Secondly, the Local Government in brackets, Miscellaneous Provisions Act 1982, Schedule 1, Public Entertainment License. Thirdly, the Public Places of Entertainment Act 1967. The local authority must decide to adopt the Private Places of Entertainment Licensing Act and also Para 3 of Schedule 1 to the Local Government Miscellaneous Provisions Act 1982, which authorizes the authority to license outdoor events, pop festivals, for these are to be operational in the district council area. In addition, the police have been involved and have utilized various legislative powers at their disposal. 2.2. The following details the association's views concerning the use of each place of legislation and suggests proposals for change. 3. Control of Pollution Act 1974. 3.1. The major impact of many parties in the creation of noise nuisance. At present, a local authority may proceed to serve notice under Section 58 of this Act at 3 distinct stages. 1. Before a noise nuisance is created, to seek to prevent it. 2. During the course of the nuisance, to seek to abate it. 3. After the event, to prevent reoccurrence. 3.2. If the authority is of the opinion that the service of a notice would afford an inadequate remedy, it can, under Section 58 of the Act, seek an injunction in the High Court to restrain the person responsible for the nuisance or the owner or occupier of the premises from which the noise is emitted to cease or prevent causing the nuisance. So they can just grab anybody. 3.3. There are a number of practical difficulties. Of course, there's going to be difficulties. 1. An authority has to establish it is satisfied that a noise nuisance will occur. 2. A notice has to be served upon an organizer or landowner, and because of secrecy, this is difficult. That's an understatement. 3. Some venues are used without the owner's permission. 4. Local authorities could be liable for a cross petition for damages. 5. An injunction to prevent or stop events depends upon the identification of defendants, counsel being briefed, and contacting a judge. 6. The identity of the person to be served are difficult to ascertain. Fine limit for contravening a notice under S58 is not commensurate with the offence and is insufficient as a deterrent. 7. There is confusion concerning the scope of injunctions, whether they can be applied across the whole of a local authority area against a particular organizer. So they want to ban you from the whole borough. There is a view that a Section 58 notice can be worded so as to require the person responsible to take steps to prevent a nuisance. An authority could use that wording to require the immediate removal of music reproduction and sound amplification equipment from the site, and if the person failed to do so, then action could be taken in default by the local authority under the powers provided by Section 69 of the Act. This itself will cause considerable difficulties for authorities in physically removing equipment safely and then sorting in a secure place. Next page. 3.4. Suggested amendments to the 1974 Act. 1. That the legislation be amended to state that the commission of a noise nuisance is a criminal offence in itself. There you go. 2. Given the profits to be made, a fine of £100,000 would not be unreasonable, but consideration be given to making the offence triable either way with an unlimited fine and/or imprisonment up to 6 months. 3. Either legislative provision or guidance be given to magistrates and judges that local authorities and other public bodies should be fully reimbursed for all costs which they occur. 4. Clarification in the form of amending legislation concerning the use of Section 58 and 69 powers for seizure of equipment. 5. A power should be added to enable an authorised officer of local authority or constable to enter under the authority of a warrant to seize and remove any apparatus or equipment or other things whatsoever found in the place for production in court. 6. The legislation should be amended to allow for the service of notices on, inverted comma, any person by whose act, default or sufferance the nuisance arises, inverted comma. This would allow notices to be served on sound engineers, persons connected with the organisation, including those who hire out equipment or transport, electricians, etc. To be effective, it must be possible to issue proceedings or notices on persons unknown, as in the case of squatter proceedings. So you can see with that one, they don't care. As I was saying before, you know, they don't care who it is. You could be anyone associated with these events or any events, because this they're not highlighting acid house here. Acid house is the vehicle, but they're not highlighting it. And you know, though my reading skills may need work, I feel like these documents, they need to be recorded. They need to be recorded, and they're not recorded anywhere else. So, you know, the job's fallen, the task has fallen with me. And so you're stuck with me. And so here we go. Continuing on this document now. It's number 4, Local Government Miscellaneous Provisions Act 1982. Miscellaneous provisions is in commas. 4.1. Provisions within this act allow the local authority to license public entertainment and to specify conditions. The provisions do not apply to public entertainment in the open air unless the authority has resolved to adopt paragraphs 3 and 4 of Schedule 1. This then allows the authority to impose conditions relating to public safety, including the maximum number of people permitted to attend the event, provision of sanitation, and to prevent noise nuisance. 4.2. Schedule 1 of the Act makes it an offence for any person to organise or manage a public entertainment without a licence, enforce, or to knowingly allow or let his premises to any person for the provision of a public entertainment without a licence, enforce. So that's anybody. If you rent me your club, you know, your field, your studio, you then fall under these laws. 4.3. An injunction can be applied for against both landowner and organizer to stop 1. the event that has to be held which would not be licensed. 2. an event which is in progress which was not licensed. Next page. 4.4. Authorities have proceeded with persecutions against persons who have held unlicensed event. 4.5. There are also practical difficulties associated with this legislation. 1. Events are organized in secret and it is difficult to ascertain organizers' names or venues until very close to the start, if then. 2. Often events are or are alleged to be organized without the landowner's permission, and the local authority must prove that he knowingly allowed the land to be used. 3. Organizers claim that parties are private and not subject to the private entertainment licensing system. It follows that a better definition of private is required for those purposes. 4. Fines are no deterrent to organisers unless very substantial, who accept them as business expenses. I mean, so you can see what they're doing with these terms here. You know, obviously they can't find ways of serving notices on promoters, and they've read all of these newspaper articles which say that party promoters are earning £250,000 a night, £500,000 a night. They're reading about party cons of £160,000 for one night's work. So they think that putting massive fines on promoters is just going to be considered a business expense because they're earning so much money from staging the event in the first place that they don't care. I mean, that's totally untrue. So 4.6, suggested amendments to the 1982 Act. 1. Penalties should be increased and set out in para 3.3, blah, blah, blah. 2, a national code of standard conditions to be adopted along the lines of the GLC code of practice for pop concerts, but also taking into account the views of Lord Justice Taylor's report on the Hillsborough disaster. One of our authorities, Tambridge District Council, Surrey, has adopted such conditions. Local authorities will be able, as now, to impose additional special conditions on a particular license. The penalties for breach of conditions would be the same for that of holding an unlicensed event. So this is why I say that this were the early stages of controlling groups of people, essentially, and all different groups of people. These early formations of these laws are what affects people in years to come after the estate. I mean, this was in November 1989, and you know they're talking about, here we go, they want to bring all events in line with pop concerts, and all of these restrictions, remembering they can tell you what DJs that you can have at your event. Well, they can't tell you what DJs, but they can say yes or no to whether or not they play at your party, so that they have got quite a lot of control over what you do at your licensed event. And if the DJ that they said can't play plays, then they treat the entire event as an unlicensed event, and so you know you get the full brunt of the law thrown at you. So number 3 of the 4.6 suggested amendments to the 1982 Act. A stop or prohibition procedure be devised similar to that which operates in the planning field. This would provide an alternative procedure to stop or prevent events without having to apply for an injunction penalty for non-compliance, would be as specified in section blah blah blah. 4, to enable any person authorized under the Act from the local authority or the fire authority or a police constable to obtain a warrant from a justice of peace to enter a place where they suspect a public entertainment is being organized or managed or about to be held without a license, enforced from the appropriate authority. This would be in addition to the power already in existence, which allows entry by warrant to an unlicensed event which is taking place. 5, to make it an offence to refuse any such person or constable entry to such a place, the penalty for such refusal on summary conviction to be an unlimited fine or imprisonment for a term not exceeding 6 months or both. So if they turn up at your private property and say, we're coming in, and you say no, you can be held under these laws immediately. So page 5 of this document, and to give you a little reminder of what document we're reading, it was a confidential document to a few years ago. It was aimed at the Association of District Councils, and it was response to a letter for information concerning acid house parties. We're almost at the end of it now. Page 5, 4.6, number 6. To enable such person or constable to enter under the authority of a warrant to seize and remove any apparatus or equipment or other things whatsoever found in the place for production in court. 7, to enable the court to order such apparatus or equipment or other things so produced to be dealt with in such manner as the court deems appropriate. 8, to empower the court to order the confiscation of all profit made by the organisation and or management of such entertainment, including the letting of the place for such an entertainment. 8, either legislative provision or guidance be given to magistrates and judges that local authorities and other public bodies should be fully reimbursed for all costs which they incur. 9. Prior to license being granted, require the lodgings of a deposit or a bond liable to forfeit if conditions are breached. And 10. A sliding scale of licensing fees determined by the number of persons permitted by the license to attend the event, should be adopted by authorities. In this way, local authorities could link the fee to the costs it will incur in administration and enforcement. The association to advise authorities on this procedure. 11. The ADC to advise authorities to adopt paragraphs 3 and 4 of Schedule 1 to the Act. And then I think this could be... And then Section 5, which is a Private Places of Entertainment Licensing Act 1967. 5.1. This legislation has to be adopted by resolution by the local authorities. It is a means by which private clubs may be controlled and does allow the authority to license and specify conditions concerning sanitation, safety, etc. So this is how they're going to control the private clubs, because as I said to you at this point in time, we were running private members clubs, and so we had grounds to appeal against, council's refusal of licenses, or even inspectors turning up at our events. We can refuse them to come on private land. So now they're trying to combat that with these laws. And they're going to use, sanitation, safety as the issues of stopping it. So 5.2 is practical problems with the 1967 Act. 1. No power of entry exists for local authority officers or police. 2. Penalties are lower than other legislation above. 3. The difficulties outlined for public entertainment licenses also imply in this case. 4. Definitions of private and public causes confusion, which at present organisers exploit by arguing that these events are private function, despite their size and the fact that in reality anyone could buy an admission ticket, which is true. 5.3 Suggestion Amendments to the 1967 Act 1. The provisions of this Act and those under Schedule 1 of the Local Government Miscellaneous Provisions Act 1982 should be consolidated. 2. In the interim, the association recommend that its members adopt the Act. 3. Fees for the grant of a license need to be increased substantially and in line with those, altered, fees for public entertainment licenses. 4. Penalties should be the same as suggested above for public entertainments. That's that bit. And number 6, other legislation utilized. 6.1. Some local authorities have advised the association that they have used or would consider utilizing Section 222 of the Local Government Act 1972, which allows injunctions to be brought in the interests of the locality. 6.2. Same difficulties appertain to the use of this power as to the use of injunctions indicated under other acts above. Now, number 7, other suggested amendments. Confiscation of the profits of organisers has been mentioned as a possibility. If invoked, it is felt that such a power should be given to the police rather than the local authorities. 8 is the conclusion. We finally got there. 8.1. The association is very concerned that events are taking place, attracting many thousands of people, which are causing disturbance and nuisance, but also at which those attending do so with no controls over safety and with inadequate organisation. Having seen over the past few years a number of disasters at large public events, the association feels that urgent actions should be undertaken to stop any unlicensed events. 8.2. To date, many local authorities and police forces have been placed under great pressure, attempting to utilize inappropriate and unclear legislation. 8.3. While accepting that major legislative change may well be difficult, this paper sets out proposals considered essential to cope with a crisis. The association urges urgent action on legislative change. And that's the end of that document. It was a bit of a long one, but we got there in the end. But you can see all the things they're trying to do here. I mean, even here in number 7, other suggested amendments. Confiscation of profits of organisers has been mentioned. It's been mentioned quite a lot, and it was profits, all profits over £10,000. That was what was being thrown about at the time. All profits over £10,000 taken off of you if that they can prove that you were involved in an acid house party, which wouldn't be that difficult, especially at a certain point. I mean, when I was doing parties, I was making the radio ads. Was fronting the parties, was leading the convoys. And so it would have been quite easy to be able to get hold of someone like me, you know. And then so to arrest me and to prove that I was creating these types of events, it wouldn't have been very difficult. So they would have taken everything off of me, basically, you know, and they would take anything off of anyone else. And the noise, obviously the noise was an issue. They really wanted to make it illegal. They really had issues with the noise. The noise is what they came after promoters with. And they want to change the law. And they used us as that vehicle to do that. The pay parties thing is quite a big thing, because you'll notice that that term pay parties, it was used after these documents all came out. They started using this term, and they really wanted the police to use that term, and they wanted the newspapers to use that term, and so everybody did. After that, they were called pay parties. They no longer called them raves, they just called them pay parties, because that is what covered them within certain laws and gave them certain powers. So that, I think for now, I think we'll leave it there. We'll leave that for the first part of my deep dive of the declassified files that were kept confidential for nearly 30 years. And sadly, only 47 were released. So we can only really go through 47 of them. And sadly, none of the police documents were released. Well, maybe they wasn't confidential in the first place, I'm not sure. But we didn't get to see any of the police stuff, you know, and their surveillance and how they were finding party promoters and how they were watching party promoters and stopping them, and all of the stuff that they did, because they did quite a lot of dodgy stuff too. All different types of things. I remember one police force, they actually created a pirate radio station, and they were directing the aim of this creating this pirate radio station was to send people to the wrong address. And this is admitted. I actually saw this on a TV documentary. That's how I know about it. And so they decided that they would give everybody the run around, tell them it was at one place, and then when people were getting near, you know, they would say, oh, it's been moved somewhere else. And it had all these people running around. And, you know, it got to a point where people ran out of petrol. And in the end, I think what happened was that they all started raiding petrol stations and stealing petrol, essentially. And I think I've got the newspaper clippings And I think it's this occasion that I'm speaking about. If it's not this occasion I'm speaking about, it is another occasion. But I'm quite sure that in this occasion, a policeman was well, allegedly, the newspapers they published a story that a policeman had been kidnapped, and it was one of these. I think it was this story. And he'd been kidnapped by a petrol station. He'd been thrown in a van or something, and driven for a certain amount of miles, and then released. With no harm done. But it was instigated by one of these type of events. I'm sure it was this event where, and I have to say, they never did it again. Well, I think it happened a couple of times, but I think when all the petrol stations got raided and all this stuff, although it generated bad press for Acid House in general, for police, they obviously couldn't be seen to be doing that, so they didn't do it again. So it would have been interesting to see whether or not any of those tactics, were ever recorded. I remember one time when they gave us all a beating. The police, they blocked us in this warehouse, and it's a long story for the party, but to cut a long story short, this party got stopped, and I remember we tried to get into the back of this building. We weren't giving up. We were like, we're going to go around the back, and we couldn't get into the building. And I remember we got trapped. It wasn't an alleyway. It was like it was a garage. It was like this long passageway. It was outdoors, it was garages, and the police basically trapped us in this passageway. And we thought that, we're going to get arrested or whatever. But all they did was give us a little beating. They lined up with their truncheons, and we had to run through them to get away. And as I said, they didn't arrest anyone. They just whacked us all with their truncheons, and were just like, that was in Bow, East London, So they were like, mate, don't come back. So yeah, a lot of things happened. There were a lot of dodgy things that happened on all sides. And this is the point. We were just this young upstarts, we didn't know any better, but the methods that were being deployed against us, we were against an entire government, the entire law enforcement. They were breaking records dealing with us kids. And it could have all been resolved, because people might be saying, yeah, but that's right. They should have been doing that. They should have stopped us. And, maybe so. But if we had at that time, a legal way of presenting those parties in 1988 in warehouses, and in the locations that we chose, then we would have followed that. We'd have adopted that. But we didn't. There wasn't licensing warehouses at that time. There wasn't licensing them. You go and they'd laugh at you, especially a disused warehouse. You had absolutely zero chance. At the time, the licenses were for pop concerts and for established pop concert promoters. So we had no looking, us young kids, in suits trying to give it, we had no chance, zero chance. And so that's why we did parties in warehouses. And remembering that at the time we were we wanted to go all night. There being granted a music and dance license for an all-night event in 1988 was rare, if it happened at all. I don't know if it even happened up until that point. So it was a rare occasion, and it was rare. So, it was a major shift in the dynamics. And so, yeah, we wasn't welcome when the licensing laws did change and people were applying for licenses. None of us could apply for those licenses because of our past. But again, these licenses were used, these licenses, laws, which were formed back then, back in my time, you know, and they were used against us, were later developed, they were improved, and they were basically used against other sections of society. Not acid house, not ravers, other people. So I'm going to do another part to this, part 2, because I've got loads of other confidential files that I think we should go over. We should learn about these things and see what was going on in those corridors of power. What were they talking about when we were dancing our tits off on a dance floor? What were they doing in those corridors of power? We want to know. And so tune in, subscribe to the channel, like, comment, share, all that good stuff. We could do with the support. We're a young channel, we're growing, and we're learning, which is the most important thing, is we're learning. And I'm not trained to read out loud, and I'm not a trained investigative journalist, but I just find things that I think are interesting, things that are connected to us, and try and present that in a way that is, palatable. So tune in to part 2. Thanks for staying for this long, and I'll see you on the next podcast.
Do you think it's anything to do with a certain religion, do you think?
No,
Is it anything
is it?
like that?
No, it's
No,
more to do
no.
with a kind of a drug, isn't it? It's a drug.
Yeah, well, those that take it ought to be ashamed of themselves.
According to The Sun, there were
thousands of empty ecstasy wrappers littering the floor of the 250-foot-long hangar.
Drugs, sex, sensation.
Some newspapers have called acid house music a sinister and evil cult which lures young people into drug taking. The message is certainly getting across.
the organisers kept the location secret until the very last moment, which was the main reason, according to the papers, why there were so few police here and they were unable to act.
Drug-crazed kids, some as young as 12, boogied for 8 hours yesterday at Britain's biggest ever ecstasy bash.
The party took place here, infiltrated by reporters from the Mail and the Sun.
There's meant to be a drugs-related craze.
What do you know about acid house music?
It must affect the brain in some way.
Unless it's just the music that does it. Who
All them
knows?
lights flashing don't do you any good either, do it? I wouldn't even go in the pub where them lights are.
Oh,
Because
no,
they drive you
no.
mad.